In this video, we're going to be talking about part 2 of the rule against perpetuities. And in the previous video, we had a little look at, how the rule against perpetuities came about, looking at Stanley and Ley, and we also specifically looked at the case of Air Jamaica and Charlton and the wait and see rule. And in this video, we're going to be moving on a little bit to talk about the Perpetuities and Accumulations Act 1964, which actually introduced the wait and see rule. So if you haven't seen my previous video, I would recommend you check that out because this video really does lead on from the previous video. So yeah, as I said, the Perpetuities and Accumulations Act 1964 introduced the wait and see rule. The trust did not become void until it became established that the trust property would not vest until after the end of the perpetuity period. So for any trust established after 1964, there is a wait and see rule. And this rule means the trust does not become void until the perpetuity rule is exceeded. So, for example, if you remember the case of Pilkington from the previous video, Pilkington would not fail, so that the case of Pilkington would not fail until the daughter actually outlived her father by 21 years. In comparison, under the old rule, just the mere possibility that the daughter would have been, just a mere possibility that the daughter could outlive her father by 21 years would have been enough to make the trust void. But under the 1964 statute, the wait and see rule dictates the trust will not become invalid until that event actually happens. So in other words, until the daughter in the Pilkington case actually outlived her father by 21 years. Another example would be in the Air Jamaica case, which I also mentioned in the previous video, hence why this is such an important sort of lead on from the previous video. So if you haven't seen that, go check it out. So in the Air Jamaica case, only those pensions where the employer married someone who was not alive when he joined the pension scheme and died and his widow had survived him for more than 21 years, only at that point would the pension scheme fail. And clearly this would not happen that often, so the new rule made a big difference. And this rule really just reduces the problems with perpetuities quite a lot. But having said that, there may be trusts existing before 1964 that are still going, and therefore the old common law does still apply to them. And there are still many trusts, and there will be for many years, that exist prior to 2009, and that is the latest amendment to the Perpetuities and Accumulations Act. Now, the Perpetuities and Accumulations Act 2009 provides that for any trust established after the 6th of April 2010, the perpetuity period is 125 years. The trust instrument must provide that the property vests within that period, subject to the wait and see rule. Okay, so under the latest amendment, which applies since the 6th of April 2010, there is no more lives in being. Trusts can now have only one perpetuity period, and that is 125 years. Trust property must therefore vest within 125 years, subject to the wait and see rule. So pre-2010, the 1964 Act applies, and post 6th of April 2010, the new Act applies. Okay. Now, it should be noted that trusts may exist for a considerable period. Okay, there are trusts set up on the majority of the life beneficiary, which could have been in existence well before the 1964 Act. Okay, a person aged 21 in 1964 would now be 70 something, 75. So, in all probability, there are many pre-1964 trusts still going. So, have a look at the case in the trust established in 1948 in Re Hawley Town Football Club, which is a case from 2006. It had a perpetuity period of the lifetime of the last descendant of George VI alive in 1948, plus 21 years. This trust, had it not been determined sooner, would have lasted until 21 years after the death of our present Queen. So this shows how long a trust can really run for. So it was established in 1948, and yet it would still be going for at least another 21 years, depending on when the Queen dies. So the perpetuity was linked to someone else completely, and that was a member of the royal period. Charitable trusts may continue indefinitely. Most charitable constitutions include a provision that, should the trust ever be wound up, the property should pass to another charitable organisation with the same or similar objects. So charitable trusts can continue forever. Charities tend not to go on forever, but some have been going on for a very long time. So, for example, back to the 13th century, Eton is a charity and has been going on for quite a long time. If charities run on steam and has money, the money must be passed on to run out of steam. They need to, and they have some money, then they need to be able to pass it on to another charity with similar objectives. And that is the purpose of having charitable trusts that can continue indefinitely. Okay? Accumulation. So an accumulation is where the income from the capital property, whether land or investments, is added to the capital rather than distributed to the beneficiaries, or where there are provisions to delay the beneficial enjoyment of the property. So you can set up a trust just to accumulate money, and usually income profit made on the property, either because of the nature of the property, because it's, for example, an investment, or through its sale, like land, will be distributed to the beneficiaries. However, with an accumulation trust, there is an arrangement whereby the trustees are directed to gather rather than distribute this income profit on the property making up the trust until there's time specified in the document that created the trust. Again, it is because it is contrary to public policy to have property tied up for long periods. There has been a prohibition against indefinite or long-lasting accumulations. So you cannot have an indefinite accumulation. If money is just being added to a pot of capital, then the property is being tied up. But in 2010, the rule against accumulations was abolished. For trusts created before the 6th of April 2010, the income cannot be accumulated for trusts for longer than one of the allowed periods of 21 years or the minority of a person in being. So in trusts created before 2010, trusts cannot be accumulated for more than 21 years or the minority of a person in being. So this would have allowed, for instance, money to accumulate over time on the trust, and on the beneficiary's 18th birthday, give them the whole lot. This rule has now been abolished for trusts created after the 6th of April 2010 by the Perpetuities and Accumulations Act 2009. So the rule against accumulations is now abolished. So there is no maximum period of time over which accumulations can occur. Okay. And finally, we have this thing called the rule against inalienability. Okay, so as well as the rule against perpetuity, there is a rule against inalienability, which is basically the same rule. In other words, property cannot be allowed to remain in trust for longer than a defined period. Okay, the rule against inalienability, that should say, only applies to a particular type of trust that we haven't actually talked about yet, and that is a non-charitable purpose trust. So trusts have to be either charitable or for the benefit of a person. Okay, you cannot have a trust for the benefit of a purpose. For example, you cannot set up a trust to promote a newspaper. But there are a small group of exceptions to this rule, and the main exception is that you can set up a trust to benefit a pet. Okay, you can set up a trust to look after your animals. And the main case here is Cooper, Dean and Stevens from 1889. And the man here left some money in a trust to look after his horses and dogs. The courts has been unwilling to leave these animals destitute, and they've upheld these trusts, but they are subject to the rule against inalienability. Okay, and the rule against inalienability, which is confirmed in the Perpetuities and Accumulations Act 2009, means that trust property must vest within 21 years. So cats and other pets may live longer than 21 years. So if you leave £10,000 on trust to provide for your cats, you have to put in a provision that the trust will end within 21 years, because there is no wait and see rule. It would be automatically invalid the mere possibility of it lasting more than 21 years is sufficient to invalidate a non-charitable purpose trust. And this is not a widely known rule, but you never know, it may come up in an exam or some situation. So it's good to bear in mind. And I thought I would just throw it in at the end of this video just so that you knew about it. But anyway, that is the end of the two-part videos on the rule against inalienability. And in the next video, I'm going to begin talking about the 3 certainties in trusts. So if you have any questions about this video, please leave a comment below and I'll get straight back to you. And don't forget to like this video and subscribe to my channel. Thank you very much for watching.